analyzing the various case studies with respect to the offer and acceptance. In case of a manufacturing company which is making an offer to supply of 500 units of goods at 100 rupees per unit on 1st January 2024 with the offer valid for 15 days. So here there is a time limit what they have given. So the offeree accepts the offer on 20th January. So 1st January till 15 days time limit was there. So the offeree is accepting the offer on 20th January. What is the legal status of this acceptance? Students, when the offer puts a time limit of 15 days, it has to be adhered to the time prescribed. So only the offer was valid till 16th January. Since the acceptance was made on 20th January, this offer was expired. Hence, as per section 6 of the Contract Act, an offer is lapsed after the expiry of the time limit specified. So the acceptance is invalid and it cannot create a binding contract. So next problem, ABC Limited publishes an advertisement offering a reward of 25,000 rupees for information leading to the arrest of a thief. The advertisement was published on a 1st March and remained valid for 30 days. Mr. P provides information on 25th March and the thief is arrested on 28th March. So calculate the reward amount. Is it valid first of all, and can he claim this reward amount is the question. Student, this is a particular case referring to the general offer. You remember that discussion on Carlyle versus Carbolic Spokeball Company, wherein when the general offer is made, even a stranger also can accept it who is having the knowledge of the offer. So in this case, Mr. P has fulfilled the condition as per the ABC Limited, whatever the information was published. So Mr. P fulfilled the condition by providing the information within the valid period, within the validity period, and the arrest occurred as a direct result. So the completion of the required act within the specified time frame entitles him to claim the full reward. So full reward is claimable because the offer was accepted and within the time frame. So this is the answer for this particular question. And the third question, Mr. A offers to sell 200 shares of XYZ company at 500 rupees per share to Mr. B on 1st April. So on 1st April, A offers to sell 200 shares at 500 rupees per share. On 3rd April, before B responds, XYZ company announces a bonus issue of 1:1, effectively doubling the share value. So Mr. B accepts the offer on 5th April, calculate the total transaction value and determine the legal implication. Students, in this case, the original offer was made for 200 shares at 500 rupees per share, which amounts to the totaling of 1 lakh rupees. The bonus issue announcement is a supervening event. Please understand it. After making an offer, this supervening event has occurred, which does not automatically revoke the offer. Please keep this in mind. Unless there is a special condition mentioned in the offer, so this supervening event of giving the bonus shares by the company will not automatically revoke the offer. Please understand. Only if there is any special conditions mentioned in the contract of offer or offer, it will not be considered as revocation of offer. So in such case, since the offer remained open and was accepted before the revocation, if the Mr. A has revoked it, it would have been the different story. But in this case, Mr. A has not revoked and Mr. B has accepted it on 5th April, which is considered as a valid acceptance, and the contract is valid. So the total transaction value is 1 lakh only. But the shares, the bonus shares uh, event will not have any impact on this particular uh, arrangement. Moving on to the next uh, question number 4. A software company offers to develop a custom application for 8 lakh rupees with the condition that acceptance must be communicated through email within 10 days. The offer is made on 10th January. The offer sends acceptance through WhatsApp on 15th January and through email on 22nd January. Students, there are two specific conditions in this case. One is about the prescribed mode of communication and the time limit. So there are 2 points which is very crucial in this case. So uh, the offer prescribed two specific conditions. So the WhatsApp mode of acceptance cannot be considered as prescribed mode, which was even done on 15th January. So that cannot be considered as valid acceptance because it was accepted through other than the prescribed mode. So, but however, the email acceptance was made on 22nd January. So, uh, here the correct mode of acceptance was done, but it was beyond the 10-day limit, isn't it? So since neither acceptance satisfied both the conditions, that is not prescribed mode, but it was accepted through valid mode but beyond the time limit, so it will not be considered as valid. So there is no valid acceptance and there is no valid contract formed. So, and moving on to the next question. A shopkeeper displays a laptop with a price tag of 60,000 rupees in his window. Mr. P walks in and tells the shopkeeper, I agree to buy this laptop for 58,000. Has Mr. P made a valid offer? Students, this question is basically when the problem says a displaying of a laptop, this is basically an invitation to offer. Invitation to offer. So invitation to offer is different from offer. So the displaying of goods, the prospectus, the advertisement, all these are invitation to offer, which means it's only an initial intention to other person to make an offer. So the display of goods with a price tag is generally considered as an invitation to offer and not an offer. When Mr. P states that he is intending to buy, so he is making a valid offer. Now it is the shopkeeper at his discretion, he can accept it or reject it. So because invitation to offer will not make a binding contract, whereas even offer also will lead to a valid contract until and unless it is accepted validly. So in this case, Mr. P has made a valid offer. Correct. But whether it is becomes contract or not, it depends on the shopkeeper's discretion. If he accepts it, it becomes contract. If he rejects it, it will not a contract. But however, he has made a valid offer. Moving on to the next question, sixth one. Mr. P sends an offer by post to Mr. Q on 1st June to sell his land for 50 lakh rupees. The letter reaches on 5th June. On June 3rd, Mr. P dies. Mr. Q, unaware of this fact of death, posts his acceptance on June 6th. Is this a valid contract? Students, uh, an offer is automatically revoked by the death or insanity. By the death or insanity of the proposer. If if the fact of death comes to the knowledge of offeree. This is very crucial here. If it comes to the knowledge of offeree, then it is invalid. So, however, Mr. Q is unaware in this case and he has posted his acceptance and it gets completed, and which leads to a valid contract. So here in this case, Q is unaware of the fact that P is dead. So an acceptance is complete against the proposer when it is put into the course of transmission. And Mr. Q had no knowledge in this case about the death of of P at that point of time. A valid contract comes into existence. These questions are all about offer and acceptance. Let us move to another interesting case study where Mr. A, who is a laundry store owner, specifically mentioned a special condition backside of the laundry receipt that customers would be entitled to claim only 25% of the market price of the clothes in case there is a loss or damages to the clothes. Kangana Ranaut, a customer, lost a new sari and claimed 100% value of the sari from Mr. A. Advise Kangana Ranaut whether she can recover. Students, this is basically whenever an offer is being made with the conditions, whether the proposer gets the knowledge of these conditions or not will become very crucial. So in this case, we have to refer to section 3, which discusses the modes of acceptance, namely by an act or by what we can say is by omission, intending thereby to communicate to the other, which has the effect of communicating it to the other. It means through act or through implied. So here some wherein there is a case law called Mukul Datta versus Indian Airlines, which states that important question over there was whether such conditions can be considered to have been communicated and treated as acceptance. In that case law, it was very much declared as yes, there was a very much valid uh, acceptance, valid communication, and which will be treated as acceptance. In another case also where Lily White versus Munnuswamy, the special conditions are to be treated as having been duly communicated, and therein a tacit acceptance of these conditions is implied by the customer's acceptance of receipt. So, based on these discussions, it can be inferred that Kangana Ranaut can recover the full price considering these as unreasonable conditions if she has protested. Students, please understand, if she has protested at the time of accepting it, she can recover. So, considering this unreasonable, because the laundry shop store owner is putting a condition that only the 25% of the market price can be recovered upon the loss or damage. So, what happens in contracts whenever the entered in the special with special conditions which are conveyed tacitly, and acceptance of such conditions are also conveyed tacitly without even realizing it, in these cases, like where similarly in courier services also, where the service provider issues acknowledgement that on the backside of the letters that service recipient who have not might have read, if the and if such receipts are accepted by the acceptor without any protest, it amounts to tacit acceptance. So so we have to be very careful while writing these kind of whenever attempting these kind of questions. We have to write very carefully as to that the special conditions should not be unreasonable, because it is opposed to public policy. Due to such condition, the laundry owner will try to misappropriate the new clothes in the given set of case study. So, in nutshell, Mr. A is liable to Kangana Ranaut because the price is whatever he mentioned, 25% is unreasonable condition, provided she should have uh, protested upon such condition at the time of acceptance. Moving on to the next question. Ram proposed to sell his house to Lakshman. Lakshman sent his acceptance by post. Next day, Lakshman sends a telegram withdrawing his acceptance. Examine the validity of acceptance in light of the following. The telegram of revocation of acceptance was received before the letter of acceptance. And in another situation where telegram of revocation and letter of acceptance both reach together. Students, the provisions of contract act says that communication of acceptance is complete as against the acceptor. You remember the discussion, the acceptor and the proposer, the communication of acceptance is differing. So for the proposer, when the acceptor puts the letter uh, into the transmission, that is the communication of acceptance gets completed. Whereas for the acceptor, the communication of acceptance gets completed when the proposer gets the knowledge. So if you remember this particular provision, uh, it will be helpful in analyzing this question. So here what has happened, in first case the telegram of revocation was received before. So in such case, since the revocation of acceptance is received before the acceptance letter, the revocation is valid. So this will become a valid revocation. Whereas in case if the telegram of revocation and the letter of acceptance both reach together, so here it is quite interesting that if Ram opens the telegram first, which is generally done by in a ordinary prudent person, a rational person, and the revocation is uh, valid in such case. But however, if he opens the letter of acceptance first and reads it, revocation of acceptance is not possible as the contract has already been concluded. So here the question arises, which is read first here? If he reads first letter of revocation, which is the telegram, the offer and acceptance will not be leading to the contract because the revocation is read first. Whereas if the letter of acceptance is read first, then the contract is formed because it is concluded whenever the proposer reads this particular letter of acceptance first. So moving on to the next question, Mr. Kapoor offered to sell his antique watch to Mr. Nair for 75,000 rupees, stating that the offer would remain open for 1 week. After 3 days, Mr. Kapoor, without informing Mr. Nair, sold the watch to Mr. Reddy. Nair learned about this sale on fifth day and immediately sent a letter of acceptance to Mr. Kapoor. Is Mr. Nair's acceptance valid? Students, please remember that a proposal is revoked by communication of notice of revocation by the proposer, isn't it? So you remember the discussion of completion of offer and acceptance communication. So the revocation is possible provided it must be done before the time limit as specified in section 6. So here, when Kapoor has made an offer to Nair promising to keep it for 1 week, however, this did not prevent Mr. Kapoor from revoking the offer before the expiry of that period, provided he communicated the revocation to Mr. Nair. However, by selling the watch to Reddy, the Kapoor has effectively revoked here, impliedly, his offer to Nair. Although Mr. Kapoor did not directly communicate a notice of revocation to Mr. Nair, the sale to the third party, but however, when it comes to the knowledge of the offeree before acceptance, it can be considered as implied revocation. So here, Mr. Nair learned about the sale on the fifth day before he sent his letter of acceptance. Once Mr. Nair had knowledge that the subject matter has been disposed of by the offerer, that is Mr. Kapoor, the offer stands revoked. Therefore, Mr. Nair's subsequent letter of acceptance is ineffective. Is ineffective, and no valid contract is formed. And moving on to the Mr. Lal offered to employ to Mr. Lal offered to employ Miss Priya as his personal secretary, provided she could produce a valid typing certificate with a minimum speed of 40 words per minute within 1 week. So there is a conditional offer. So Miss Priya accepted the offer but failed to submit the required certificate within the stipulated time. So the legal provisions of the contract act states that whenever acceptor fails to fulfill the condition precedent to the acceptance, the proposal stands revoked. So in this case, when the Mr. Lal's offer of employment to Priya was conditional, this was a conditional, and such conditions were not fulfilled by Priya, and she accepts the offer, but her acceptance was subject to the fulfillment of conditions. So since she fails to provide the required certificate within the time frame, uh, 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 Priya's acceptance is considered as invalid, and Mr. Lal is free to withdraw his offer or consider it as terminated without any further communication to Priya. So there is invalid acceptance because accept conditions were not satisfied by Priya, so which leading to the um, invalid acceptance, and there is no valid contract is formed. There is no valid contract is formed.